the original charges, he's following people, taking pictures of.
Let me know when you're ready there, Robert.
We're ready whenever the court's ready.
Okay, great. All right, we're next taking up the case of People of the State of Michigan versus Dana Alexander Scott. File numbers 26-3657FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Missaukee County.
Robert Hartzell for Mr. Scott, who joins me at the table, Your Honor.
Thank you. Also here this morning is Mr. Luke Blazak. He's the agent from the Michigan Department of Corrections here today. We're here for a sentencing on a probation or set of probation violations. The defendant resolved them with a plea of no contest to count one, and then the remaining counts would be to be dismissed. Is that correct? Correct, Mr. Blazak?
I thought it was like counts six, sure.
Well, I'm looking at the form, the journal form that the clerk gave me, but it could be incorrect. Looks like he pled guilty, no contest to count one,
Yes.
for violating Rule 1, and the others were dismissed.
Yes. Yeah.
Okay. All right. Yep, we got it. Thank you. All right. So I've got the recommendation here. Any objections to the content therein, Mr. Ringstrom?
No, Your Honor. There's no full verification of it yet, but we had heard that charges have been pressed in Wexford County now. But
In which county?
Wexford,
Okay.
That is accurate, Your Honor.
All right. Thank you. Mr. Hartel, any corrections or anything we need to address here?
No, Your Honor, after sidebarring with my client about it, we don't have any corrections to it, no.
All right. Thank you very much. Is he currently, all right, the sentence was issued back in April. He had only 38 days left to serve, so he must have served that. Then he got arrested on the request and warrant.
That's correct, Your Honor.
Okay. And are the new charges already filed?
They are, is the bond 50,000? I'm not sure. I'm not sure exactly what the bond is, but they have been filed in Wexford, yes, Your Honor.
Has there been an arraignment though?
There has, Your Honor.
Okay, thank you. All right, well, let's go ahead and jump. There's no challenges to the content. Let's go ahead and jump to allocution. Mr. Ringstrom, what do you think?
I think that the defendant here needs to go to prison at this point in time. He's sitting there. The original charges, he's following people, taking pictures of them naked, stalking them basically, and all of that stuff. And one of those victims was a 10-year-old girl, and here we are now, just within 30 days of his being released. He has more photos of that, very bad photos of young children on his phone. I think at this point in time, he has shown that regardless if he gets released again, he'll just do the same thing at this point in time. So I agree with the recommendation. I think that he should go to prison. I don't think that him being watched by us is going to help much.
Mr. Hartel.
Thank you, Your Honor. I know we entered no contest here, plus those charges are pending presently, so I won't overly allocate to the exact specifications of what there's a finding on that occurred. What I will say is I have met with my client, although I would encourage him not to make too many statements today for those reasons. He's cognizant of the fact that he needs mental health treatment. He wants to make sure he's not in front of the court again without doing any additional statements into depth. But he is very much aware that he needs help. He wants to get that help. And we're hoping that if he goes to prison for a short sentence, that he can get that help there.
All right, thank you very much. Mr. Blazak, could I see the previous PSI? Thank you.
Yes.
Now, Mr. Scott, I understand, I don't, because that you entered a no contest plea, I don't anticipate in most of those instances that a defendant's going to say anything, but because you've got those other charges pending. So if you don't say anything, that's perfectly fine. I'm not going to take it and apply it negatively, but I just need to let you know you have the right to make a statement if you choose to do so. Is there anything you wish to say?
Only to reiterate what my attorney has said, that I do severely need mental help, and I have for many years.
Sure.
Just lack the ability at one point or another, for one reason or another, to seek it.
Sure. I understand. Well, you know, I'm not um, taken away from the importance here, difference, distinction between this and other things. Everybody has, so, at least most will seem to have some kind of drive, action that they're often unable to control, and because it's part of them. Whether it's alcohol, gambling, chocolate, I don't know, especially dark chocolate for me. Woof. But anyways, and I'm not trying to say that that's the same thing here, but the point here is just your acknowledgement of that is a good step. And I really appreciate that. And I think that can be helpful for you. All right. Well, the next challenge I really have here is the processing of the other case. I mean, if I send him to a prison, he's not here to be, makes it more difficult. But at the same time, the sentence isn't supposed to necessarily try to consider what's helpful for the prosecutor and defense attorneys. It's really to help the defendant. And I know if we leave him here, there's really no health care. There's no mental health treatment here in the Stockton County Jail. I'm not picking on the sheriff's department or the county. That's just the way it is in small parts, the smaller counties in Michigan. We don't have that kind of treatment. We don't have it available. Mental health is really only going to come down if there's an emergency, like a suicidal ideation, things like that. But they rarely have the time and money or funding to be able to do everything that's needed of them. So that's not picking on them. It's just a part of reality. So I want to help the defendant get the help that he needs. To me, that is priority number one. He has had some impulse control issues in the past. We see the retail fraud, some violent actions in the past. So I am concerned here about impulse control. The court therefore sentences the defendant as follows. The court sentences the defendant. It's within the guidelines. While the guidelines are an intermediate sanction, the court finds, based upon the violation here in the file, that there are reasonable grounds to give further confinement. The court therefore sentences the defendant to a prison term of 16 to 48 months for count 1, the possession of CSAM, and for count 2, which is surveilling an unclothed person, the court sentences the defendant to 16 to 24 months. That, of course, is the most that I could do on that. That is outside of the guidelines, but I find it to be a reasonable proportionate. And it's at the 2/3 level. So that's the highest the court could ever go anyways. The court awards the defendant 200 days of credit. Any fines or costs ordered previously are preserved. And again, probation is terminated unsuccessfully. Have I missed anything, Mr. Blazak?
I don't believe so. Thank you, Aaron.
Mr. Ringstrom? All right, Mr. Hartel is going to bring to you, Mr. Scott, 2 copies of one document. This document you've already seen before. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt to your copy of the document. This document tells you that you have the right to appeal the conviction and sentences in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All right. Mr. Scott, thank you for your acknowledgement today. It's not really acknowledgement as far as your Fifth Amendment rights in the other case, but what I mean is I thought your words were insightful. They were short, but they were insightful enough. So I sincerely do wish you the best of luck. Anything else, Mr. What's your name again? Hartel. Thank you. All right. Anything else besides that document? All right. Thank you.
In this hearing, Judge Fleischer reached his limit after learning that Houston police could take up to 11 months to provide crucial video evidence. The judge made it clear that justice delayed is justice denied, saying these long delays are unfair to everyone involved: the prosecution, the defense, the victims, and the court itself. To keep the case moving, the judge ordered officers to appear in court with the video evidence or face possible contempt proceedings. It was a strong reminder that accountability applies to everyone, including law enforcement. What do you think? Was the judge right to demand faster action? Let us know in the comments below. Thanks for watching. If you enjoyed this courtroom breakdown, please like, share, and subscribe to our channel for more courtroom drama and legal analysis. Turn on the notification bell so you never miss our next video.